Pate.
Thank you, Madam Speaker, and thank you, honourable colleagues. Honourable Senators, I speak today in support of Bill S-232. Thank you, Senator McPhedran, for your leadership on this issue and your tireless work to shine a light on the harms, injustices, and inequalities that non-disclosure agreements cause, as they too often obscure and protect and thereby perpetuate abuse. Non-disclosure agreements originated in the 1980s as a means of protecting the markets and profits of tech businesses in Silicon Valley, preventing employees and others from divulging trade secrets. In 1984, a U.S. federal judge, Miles Lord, issued a courtroom reprimand exposing settlement agreements that the A.H. Robbins Company used to silence women injured by the Dalcon Shield intrauterine device. Judge Lord stated, and I quote, "If one poor young man were, without authority or consent, to inflict such damage upon one woman, he would be jailed for a good portion of the rest of his life. Yet your company, without warning to women, invaded their bodies by the millions and caused them injuries by the thousands. And when the time came for these women to make their claims against your company, you attacked their characters. You inquired into their sexual practices and into the identity of their sex partners. You ruined families and reputations and careers in order to intimidate those who would raise their voices against you." End quote. Then, in a situation that simply beggars belief, Judge Lord himself was subsequently silenced. On appeal, the company that had injured and killed women succeeded in convincing the court to strike the judge's comments and expunge the record. Since then, the use of NDAs has grown exponentially, forcing silence that primarily serves to protect wealth, power, and privilege. In Canada, the best available data indicate that nearly all sexual harassment settlements include non-disclosure agreements. Some 1 in 10 Canadian workers who have experienced harassment or discrimination have been required to sign an NDA as a condition of settlement. Those who sign are disproportionately women, racialized folks, those living with disabilities, those who are impoverished or financially precarious, and those who have been victimized by someone in a relative position of power and privilege. People who sign usually do so as a condition of receiving a financial settlement. Too often when they are in economically disadvantaged circumstances and when they believe they have no other options. Too often, NDAs are signed by those who fear the backlash and attacks on them, and when it seems that abusers won't be held accountable in civil or criminal trials. Simply put, they most often believe that they have no choice. Experiences of some 130 victims and survivors who have signed NDAs were collected by Can't Buy My Silence, an organization co-founded by Julie McFarlane, Emerita Distinguished Professor of Law at the University of Windsor, and Zelda Perkins, a woman at the forefront of the Me Too movement, the first to break a non-disclosure agreement signed with Harvey Weinstein. Survivors spoke loudly and clearly about what it means to be silenced by NDAs, highlighting patterns of coercion, time pressure, lack of information, exploitation of financial and other power imbalances, and dismissal of any concerns raised. One survivor said, and I quote, "I was given just 10 calendar days to accept or reject the settlement, including the NDA, creating immense pressure to decide without adequate time to consult a lawyer or fully assess the implications. The rushed process felt deliberately designed to limit my ability to resist or seek alternatives." End quote. A common myth is that those who report abuse are the ones who seek NDAs for their own protection. NDA signers report not being offered ways of protecting their own privacy without also agreeing to protect institutions and abusers in return. Too many do not even receive copies of the settlement agreements they sign. Legal experts note that NDAs are intentionally worded in ways that make them difficult to comprehend. Dr. McFarlane says, quote, "I have never spoken to anybody, no matter what their level of education, who fully understood the consequences of a non-disclosure agreement when they signed it." end quote. What are some of the consequences? People who sign NDAs are prevented from speaking, even to family and friends, about what happened to them. They are unable to warn others. They often worry about whether, or worse yet, see the evidence that their abusers go on to harm others. Can't Buy My Silence indicates that while half of victims left the workplace after experiencing harassment or abuse, only 5% of those who victimized them left or moved. Abuse continues and abusers are protected. When settlements with the Canadian government and its agencies contain NDAs, the cost of all of this, silencing victims, protection of abusers, leaving in place conditions for future abuse, is funded by public money. Canadians are the ones whose tax dollars pay for these predatory arrangements. Too few of us know this precisely because NDAs enforce silence. Bill S-232 would notably ensure that the Government of Canada does not spend public money on, 1, the settlement agreements related to harassment, violence, or discrimination that silence people through NDAs, and 2, on legal action to punish those with NDAs who speak out about them and what happened to them. The bill would not prevent victims and survivors from choosing to protect their own privacy through NDAs or otherwise. Rather, Bill S-232 would recognize the reality that NDAs currently and overwhelmingly operate to protect institutions and perpetrators of injustice rather than victims and survivors. It would aim to ensure that Canadians do not support and assume the cost of re-victimizing and punishing survivors of discrimination and violence. For nearly 5 decades, I've had the privilege of walking into, and more importantly, out of federal prisons. As senators, we have statutory rights of access. Those of you honourable colleagues who have exercised this right to visit prisons know the feeling of moving through multiple layers of barbed wire fences, stone walls, metal security doors, guarded gates, and security checks. Who controls entry and departure of people and information is palpably clear. When the rights of a prisoner are violated by someone responsible for their care and custody, they are violated by the very people and entities who control whether a prisoner can reach lawyers or other supports. Prisoners do not have access to email. Most are impoverished and can neither afford nor access adequate legal, mental health, or other vital supports. For those who can afford to pay for phone calls and stamps, corrections still controls access to phones and even to pens and paper and information. Corrections also creates and holds records, from the prisoner's personal file to video cameras and recordings. When they appear in court, as law professor Emma Cunliffe has documented, the accuracy and reliability of the record-keeping that they provide are all too rarely questioned. Can you imagine mounting a successful court challenge under such an extreme imbalance of power? Would you even try, given the documented risk of reprisals within prisons against those who speak out about wrongdoing by prison authorities? Virtually every prisoner who bravely brings forward a complaint that could give rise to a human rights case or criminal charge is met with an offer of a cash settlement with a prerequisite non-disclosure agreement. Most people in this situation are struggling financially or personally, particularly if released from prison, with how to live, how to work, how to afford to be in the community. People accept these settlements because they need resources to address their basic needs to live, to eat, and to house themselves. They lack the resources to go to court, even though they would almost certainly thereby receive a larger amount of compensation and more effective accountability. They can't afford to wait for the months or years it may take for a tribunal or a court decision. This, in addition to their isolation and criminal record, makes them both desperate for relief and justifiably fearful that they won't be believed, and therefore uncertain of any alternate result. Because of the NDAs attached to these settlements, information relating to these abuses rarely becomes public knowledge. Patterns of abuse or other wrongdoing remain shrouded, and knowledge cannot be shared. Perpetrators of injustice and wrongdoing are protected. If a victim even inadvertently or unintentionally breaches an NDA, such breaches are often litigated and victims charged with contempt and ordered to pay back the compensation and sometimes even jailed for contempt of court. Between April 2022 and the end of 2025 alone, the Government of Canada paid out more than $74 million in public money to 200 federally sentenced people under settlement agreements. Some of these are related to public court settlements, but the vast majority of these arrangements, 88%, included non-disclosure requirements. When I speak in this place of relative power and privilege about the prison system, honourable colleagues, I often try to share the story of someone with whom I've worked and walked and how they struggled with the injustice that we're discussing. Today, government-initiated NDAs preclude me from doing so. How is this helpful, let alone fair or just? Within prisons and beyond, those who take advantage of secrecy and silencing through NDAs are too often the very people whom we expect not only to uphold the law, but to model appropriate behaviors. Many of the allegations they face concern breaches of the criminal law and charter and human rights, backed by clear and often uncontrovertible evidence. This is what an NDA renders invisible. What example is set when those responsible for protecting us are unwilling to correct their own behaviors and then hide those behaviors from us? Colleagues, the government has stated its commitment to redressing violence against women and girls, as well as to implementing the TRC calls to action and the MMIWG calls for justice. Most Indigenous women in prison have experienced the horrific legacies of residential school, as well as child welfare and additional abuse and trauma. There is much to be done to eradicate the racism, colonialism, misogyny, and other systemic economic and social inequalities that underlie this violence. Bill S-232 is not a panacea, but it is an important step to address the misuse of non-disclosure agreements by federally funded entities. It will allow Canada to invest not in buying silence and further persecuting those in vulnerable positions, those who are victimized by others in positions of authority, but rather in healthier, more just, and more equal communities for all of us. For these reasons and more, I am grateful for and happy to vote in favour of this bill. Jimigwich, merci. Thank you.
Senator Down, you have a question?
Yes, I have a question if Senator Pate would take a question.
Yes.
Senator Down.
Thank you. Senator Pate, as you may be aware, Prince Edward Island passed a non-disclosure agreement, the first province in Canada to do that, and I believe it was in 2021. It was proposed by Lynn Lunn, who was then part of the opposition, the Green Party opposition. The Conservatives were in power and the Liberals were the third party. I'm glad to report that's reversed now. The Liberals are the second party in PEI. And it was unanimous in the PEI legislature to pass it. Have you studied the positive impact that non-disclosure agreement has had in PEI when you were doing your research for your speech?
Senator Pate.
And in fact, the people I spoke to talked about the PEI legislation, so thank you, Senator Down, for raising it as a model that could be looked at for other jurisdictions as well as for Canada as a whole. So thank you very much for raising that.
Senator Down.
Thank you. I'm not, I don't have your experience or expertise on prison work, but what the non-disclosure agreement, the major impact it appeared to have in PEI was the impact it had on women who were, as you correctly identified, silenced on a go-forward basis for any sexual harassment or abuse that they suffered. But the biggest problem was they couldn't warn others. So we've had situations, we had, unfortunately, a president of the university who was involved, and the rest of the university community was unaware of what was going on. The release and removing that has had a tremendous impact on the safety of women in Prince Edward Island. I assume that was part of your research as well.
Senator Pate?
Well, in fact, as you may recall from my speech, one of the realities is that in the situations where people have tried to use non-disclosure or have tried to challenge non-disclosure agreements, because of their recognition, they're seeing other people going on, or other people being abused by the perpetrators who they had to deal with. They have been punished. In fact, as I mentioned, there have actually been women who have been jailed for contempt because they have tried to challenge the NDA.